What is guardian advocacy, and are there any other alternatives? The answer coming up in Know Your Rights. Welcome to Know Your Rights, your source for free legal education. Welcome to another edition of Know Your Rights. My name is Roberto Cruz, and I'm the Advocacy Director for Florida Rural Legal Services. With me, we have my son, Alex Cruz. Alex is my son. He just turned 18 last year. He's been diagnosed with autism, and we had to make a decision on what to do to help him make some of the choices that everybody needs to make in life. And we decided to go with the guardian advocacy. And today, that's the subject that we're going to discuss. Say hi to everyone, Alexis.
Hi, everyone.
All right.
Today's topic on guardian advocacy and other options in decision making is brought to you by Florida Rural Legal Services in collaboration with Florida Legal Services and my friend Christy Bagalow, Director of Statewide Training Initiatives. If you're like me, you're going to have questions about guardianship in general. You will also question whether guardianship is the only alternative for you or your loved one. And finally, you'll want to know the consequences of choosing guardianship versus any other alternative. Now, in order to put things in perspective, we're sharing this news report.
Now at 5, News 6 has learned change is finally coming to strengthen guardianship laws here in Florida. It comes as a criminal investigation continues into former Orlando-based guardian Rebecca Furley.
State investigators are trying to see if she broke state law after placing do not resuscitate orders on hundreds of Floridians. Her attorney says she has not broken any laws and just last week filed an appeal to the 5th District Court to step in. News 6 investigator Adriana Ivashinsky has been following this story since the very beginning. And Adriana, you spoke with local lawmakers about a new bill that is now in the works.
Yes, I did. The language is still being drafted, and there is a big meeting up in Tallahassee tomorrow with several people who have a stake in the guardianship issue. We're talking judges, guardians, families, representatives, and senators on both sides of the aisle.
So we've got a lot that we need to look at in order to make this program work.
State Senator Linda Stewart says she has a vested interest in guardianship reforms since Rebecca Furley's Orlando-based office falls right in her district.
There will be something done this year.
Can you guarantee that?
Yes.
Senator Stewart says she was floored when she learned not only how many guardianship cases Furley took on, but that she placed do not resuscitate orders on most of her clients and then double billed both them and Advent Health for her services to the tune of almost $4 million over a 10-year span.
There will be action taken because we can't allow this to continue.
Just last week, Furley's attorney filed these appeals to the 5th Circuit Court, stating Florida law is actually on Furley's side when it comes to the DNR issue, stating once appointed, guardians are not required to get the court's or client's permission to order a DNR.
That's going to change.
News 6 has learned right now Florida State Senator Kathleen Pasadomo and Florida Representative Colleen Burton are working on a bill that would add more oversight on guardians.
It is certainly not acceptable and would not be acceptable to any guardian that I've talked to, that I've dealt with, to issue a DNR order over the objection of a ward and their family.
A state investigative report filed in July revealed Furley admitted it was common for her to file DNR orders regularly on her clients, and that for her it was an issue of quality of life over quantity. Senator Pasadomo says her bill would require state guardians to have to get a court order no matter what.
It's unthinkable to me that someone would do this, but now we're going to have to put this in statute just to make sure nobody else does.
And Senator Stewart says she will back up her fellow senators on this mission and plans to co-sponsor the bill. She says what happened under Furley's watch should never be allowed to happen again.
I think that this person took advantage of our seniors, and they really need to be protected. And if we're going to rely on guardianship to be the protector, then we need to make sure that we are protecting them and that there are accountability in place for our guardians.
And of course, there is also federal legislation being presented up in Washington to strengthen guardianship laws across the country. U.S. Representatives Darren Soto and Charlie Crist are leading the charge on that. And I'll have more on what Representative Soto has to say about this push to change Florida's guardianship laws and also the change one head judge is making in his district to make sure that they can monitor guardianship cases better in the future. All of that is coming up tonight at 7 o'clock and also on clickorlando.com.
It definitely seems like there needs to be more accountability. I mean, all of this was happening kind of in the dark and the double billing that so many people were
There
unaware
are a lot
of.
of things. I mean, what I've talked to with the lawmakers and even with the Guardian I spoke with last week, you're supposed to do the right thing. But sometimes there's a gray area in the law, and that is what they're trying to address, that gray area. So there is no gray area.
Yeah, and oddly enough, it's taken this long to address those issues.
It's very, very sad, but we're on top of it, and we're going to keep on it every step of the way.
All right, Adriana, thank you.
Now, that was a scary story, and we definitely don't want those things to happen to our loved ones. The way that the Florida legislature is making sure that that doesn't happen is by restricting the options that people have to allow somebody else to make decisions for them. So if you go to a judge and you're asking for some authority to make decisions on behalf of a ward, the court is gonna evaluate whether that's the least restrictive alternative possible. Meaning, is there any other way that we can make sure that our loved one can make decisions without taking away their rights?
In order to make sure that you know your rights, you're going to have to learn three major things. Number one, what options are available to children turning 18 and in need of assistance making decisions. Number two, is Guardian Advocacy the right option for you or your loved one? And three, how do you or your loved one obtain a Guardian Advocacy? But first, let's talk about options. Your rights give you the ability under the law to make decisions that can affect your quality of life. Now, some of the rights that we're talking about here are the rights to select where you live, manage your money or property, consent to medical or dental treatment, request public benefits, select social activities, select your friends, marry, or even find employment. Now, what happens if you need help making these kinds of decisions? Well, Florida law offers several options, and the key is that you will have to choose an alternative that is the least restrictive on you or your loved one's rights. And what are the available options? Well, there are several, and we're going to discuss only the most relevant ones, beginning with direct decision, followed by banking services, power of attorney, representative payee, advance directives, healthcare proxy, trust, and guardianship. Let's talk about decision making. Now, the first option that you have is making the decision yourself. You might want to consult with a friend, but that friend will have only influence over you. They will not make the decision for you. Ultimately, you or your loved one will be the one making the choice. When it comes to finances, you can always arrange banking services to fit your needs. You can assign someone the power to act on your behalf over matters relating to your bank account. You can create a joint account with two or more people, and you can also establish a direct deposit system. The next alternative is the power of attorney. Now, with the power of attorney, you can authorize another adult to act on your behalf over general or specific matters. If you only need help paying your bills, then you can specify in a power of attorney that you want your agent to act on your behalf only to pay your bills. On the other hand, if you give out a general power of attorney, then your agent will be able to buy, sell, borrow, and do all sorts of things with your property. Not only that, but that person could also make some personal decisions for you. If you don't want that to happen, then you will want to be as specific as possible as the acts that you want to delegate. Another thing about the power of attorney is that there is no oversight. This is a private document. The only thing that you can do is either revoke a power of attorney, or you can, after the fact, file a complaint with the court if you believe that the agent has not acted on your best interest. But there is no oversight by any public authority over that private agreement. Now, there's another form of a power of attorney called a durable power of attorney. Now, this gives your agent the authority to continue to make decisions for you after you become incapable of making any choices. This is usually used by people who are suffering from a condition like Alzheimer's. When you know that you're going to have Alzheimer's, you need to make preparations. And you can, with Alzheimer's, make some decisions. But ultimately, you know that there will be a point where you are going to need help. And what a durable power of attorney does is that it allows your agent to make decisions for you even after you're not able to do it for yourself. You don't need to go to court in order to do this, which actually is a better and more economical option than going to court and getting a guardianship appointed, or making the court determine that you are incapable of making those decisions. Now, that is a costly process, and a durable power of attorney is really very economical as compared to a judicial process. Now, any competent adult with a disability and with the capacity to make informed consent can execute a power of attorney or a durable power of attorney. So, in practical terms, if you have a son or a daughter or a loved one with a developmental disability, and that son or daughter has the capacity to make decisions, then you really don't need a guardianship. This person just needs help with some aspects of their lives. They have the capacity to delegate some of those functions to somebody else, and a power of attorney or a durable power of attorney will suffice. It's a private document. You don't have to go to court, and it'll make matters easier. Now, if the person does not have the capacity to make informed decisions, then a power of attorney or a durable power of attorney is not an option. Now, remember, the court is going to look for the least restrictive means of making uh, sure that your loved one or you makes decisions. So if you're going to ask for a guardianship and the court finds that the ward or your loved one has the capacity to make decisions, then guess what? Your petition for a guardianship for a court order will be denied, and you will be told to look for other means like the power of attorney. I'm a parent. I understand. Our kids, when they turn 18, they are not necessarily mature enough to make decisions on their own. Uh, I remember going to college. I wasn't making the best decisions when I was 18, uh, but I had the capacity to understand and made informed decisions. Not good decisions, but informed decisions. So uh, a court is gonna tell you, well, this is not a matter of informed consent. It's a matter of adulting. Basically, you have an 18-year-old that is messy and is really maturing. But if they have an IQ of more than 70, usually the court will say, well, yeah, this person has a right to make a decision to be messy and to be irresponsible in paying the bills, but it's just a matter of maturity, not capacity. The next alternative is your representative payee. Your representative payee is a title that is conferred by the Social Security Administration when your loved one or you are receiving benefits, but you need help making sure that the benefits are spent in the right way. Instead of the beneficiary receiving the payment, you or your loved one, as a representative payee, receives that monthly payment of benefits and is responsible to the agency over how the money is spent. This is usually done when a person with a developmental disability is on Social Security income or SSI, and that person does not have the ability to make decisions on his or her own, and the Social Security Administration will then delegate that function of managing the assets to that representative payee. Advanced directives is another form of um, decision making options. And what you want is for your choices about healthcare to be publicly known. And in addition to that, you can also name someone to make some of those medical decisions for you if you become unable to make those decisions about your own medical treatment. Now, earlier, we talked about the Do Not Resuscitate Order, or DNRO. That's a form of an advance directive because you're stating that if something happens to you and there is some kind of medical treatment that will enable that person to save your life, you want uh, the option made known that you don't want to receive any kind of life-saving treatment. Now, if you don't make that known, and that's a problem because then you will delegate that function to somebody that you may not trust. So, word to the wise, Advanced directives is a great idea for everyone. Now, what's the problem of not making an advanced directive? Well, the problem is that you will find yourself with a health care proxy. Now, what that means is that under the healthcare proxy statute in Florida, there will be an order of people who can make healthcare decisions for the incapacitated person that is unable to make the decisions for themselves. Okay? If you don't have a written DNR, then that's fine. But if you look, the first in line is the court appointed guardian. Now, that's what happened in the previous news report. If you don't have any kind of document saying that you don't want a DNR, then that choice will be made by the appointed guardian. So when the guardian placed the DNR on all of the wards in her care, she just raised the defense that she was acting in accordance to the law. Now, as a consequence of this loophole, the court amended, well, not the court, but the legislature amended the statute that regulates guardianships. And now, every year that you need to inform the court about your functions as a guardian, you need to include a clause that says that there are no DNR directives in place for the ward. And if there are some, then you need to report it so you will be investigated. Okay? Now that's a new change that became effective this summer of 2020. So if there's no guardian available, then the family members or any friends can make those decisions under the healthcare proxy statute here in the state. Another decision making option available is the trust. Now, trusts are a very complex legal fiction, and a trust is nothing but a document in which a person with some assets called the depositor takes a certain amount of assets and deposits them in the care of somebody called a trustee. Okay, kind of like a manager of the assets. And the trust document are the instructions for that trustee, that manager of assets, to take care of that property on behalf or for the benefit of somebody else. And this functions kind of like a corporation. So it's a different entity by itself. And as soon as the depositor leaves those assets to the trust, those assets cease to become property of the depositor and now are property of the trust. And that trust needs to be managed following the instructions of that depositor. If the trustee does not follow those instructions, then that trustee needs to answer to the court. There are different kinds of trusts. Now, the typical trust is made in order to avoid probate. You know that you really don't want to pay the debt tax, and you really don't want people to start fighting over your assets in court after you die. And those are some of the reasons why people um, do these trust documents. There are other less typical trusts like the special needs trusts. Now, special needs trusts are specifically designed to make sure that the beneficiary keeps receiving public benefits. So, remember when I told you that the trust is kind of like a corporation and it has its own personality, so it owns assets aside from anybody else? That's important because if you want to be eligible for Social Security income or SSI, there are certain requirements that you need to follow. For instance, you can't have more than $2,000 in your bank account. If somebody else is the owner of some assets that benefit you, like a trust, but it's not really money deposited in your bank account, then you're still eligible for SSI benefits. Okay, you still need to notify the Social Security about the existence of the trust in your benefit, but there are specific laws that allow you to have those special needs trusts in place. Okay. Otherwise, if the trust didn't exist and there were more than $2,000 in assets um, in the beneficiary's name, then your loved one or you might be disqualified uh, from receiving those benefits. So yes, um, a special needs trust is an option. So you can make sure that your loved one or you fully receive public benefits and that you have a trustee, somebody that has the instructions on what to do with that money, and you have some sort of accountability from the court if that trustee does not um, abide by the instructions that were set out. Finally, we have the guardianship. Now, the guardianship is the most restrictive option for those people that need help in making decisions. It requires the court to do two things. Number one, declare that somebody is not capable of making decisions, and that is a costly thing to do. You usually need a panel of doctors to review the case and make a recommendation to the court, and that is not necessarily affordable. And the second thing is that the court will transfer all or some of your rights to the guardian. There are different types of guardianships. The least restrictive one is guardian advocacy. The most restrictive one is plenary guardianship. We're going to start with plenary guardianship in order to facilitate our discussion. Plenary guardianship is awarded if a court finds that you're incapable of making decisions, number one. After that determination is made with the assistance of a medical panel, the judge will designate a guardian. And once that designation is made among family and friends, and maybe a private guardian if none of the previous options are available, then the court will transfer all of your personal and property rights to that guardian. Now, it happens to a lot of seniors with no relatives or friends, that the court will determine the incapacity, designate a private guardian, and then transfer all of that ward's personal and property assets to that guardian. That's a scary proposition. So we want to make sure that we make a good choice, or that we present a potential good guardian to a judge. Following that, you have the limited guardianship, and that's when a court finds that a person is incapable of making decisions in specific areas. It's usually financial. A person may marry, vote, choose to live a certain lifestyle, and that's okay. A judge can designate a guardian to help you only in those areas where you need help. If it's strictly financial, then so be it. Next, we have the emergency temporary guardianship. That happens when you're in imminent danger and your ability to make decisions is questioned in a court of law. Usually, this happens to people that are involved in car accidents. If you have a person that needs some kind of emergency treatment, and that person is unconscious, then you will need an emergency temporary guardianship in order to make that decisions for that person if there are no advanced directives associated with the designation of a healthcare surrogate. So if there's no one to make those decisions for you, there you're gonna need somebody to be appointed a temporary guardian. Now, this kind of guardianship expires in about 90 days. If the and That usually happens when that temporary guardianship is not followed up by a request for a permanent guardianship. Voluntary guardianship. Well, that happens when a person is unable to manage their properties, but they are otherwise mentally competent. Usually, this happens to somebody with some kind of condition that allows them to make personal decisions, but that person is aware that they are not able to make financial decisions without assistance. Now, at any moment, that person who volunteered to have a guardian appointed can withdraw that consent and terminate the guardianship by going to court. Finally, we have guardian advocacy. And one of the things about guardian advocacy is that you're not required to demonstrate the ward's capacity. In other words, you don't need to hire a panel of medical experts to determine that your loved one is incapable of making decisions. That is a very costly proposition. So, through this process, a guardian advocacy is definitely more affordable than the other guardianship alternatives. Once you submit all the documentation needed, then the court will transfer all the necessary rights for the care of the person or property of the ward. Now, this is the least restrictive and costly alternative for people with developmental disabilities. So, this is not available to everyone. This is really available to people with developmental disabilities. And there you have them. Those are all the most important alternatives for your loved one and you to make sure that you or your loved one has some assistance in making decisions. Now, it's hard to determine which option is good for you or for your loved one. And in order to help you in choosing the right alternative, there is a website that was developed. It's called Turning 18. And you can just go to turning18.org, follow the steps, answer the questions, and at the end, you will have an analysis with a recommendation on what would be the best option for you or your loved one. Now, of course, after you make that choice, the process doesn't stop there. Congratulations. So you looked at all the alternatives, you went to turning18.org, you analyzed, you got a recommendation, and it came up that Guardian Advocacy is the best option for you. Great. Now what? Well, this is when the work starts. The second step is for you to make sure that Guardian Advocacy is right for you. Now, in order for us to do that, we got to look at the actual statute to see whether your loved one actually qualifies for this kind of alternative. First of all, we need to understand what guardian advocacy is. And guardian advocacy is defined as a process for family members, caregivers, or friends of individuals with a developmental disability to obtain the legal authority to act on their behalf. Okay? So that designated person is going to have the authority to act on someone else's behalf. The only difference between this alternative and some of the other alternatives is that there is court oversight and that it is an appointment made by a judge, not a private document, but a public document that is subject to review. Now, under the Florida law, a person considered to have a developmental disability has been number one, diagnosed with a mental retardation, cerebral palsy, autism, spina bifida, Prader-Willi, Down, or Phelan-McDermott syndromes. Now, I don't like some of the terminology that they've used here, but that's what the Florida statute says. So we're just going to have to live with that. And number two, one of those listed conditions must be manifested before the age of 18. So it can be something that was caused by a car accident, something that developed late in this person's teen years. It needs to be something that was diagnosed before the age of 18. So if we're talking about autism, if somebody suspects that they have autism and they don't get a diagnosis until after 18, that person may not qualify. So you need to get somebody to diagnose you or your loved one before you reach the age of 18. And number three, that condition constitutes a substantial handicap that can be expected to continue indefinitely. So basically, there's no cure. If you have autism, there's no cure for autism. And yes, there are some people that are proposing some cures for autism, um, and that may be your point of view, but for legal purposes, um, it needs to be a permanent handicap. And again, I'm just using the legal language um, included in the statute. One of the important things that we need to look at is the word substantial handicap. Okay? Now, that is subject to interpretation, to say the least. There are some parents that believe that their children are substantially handicapped. Um, so, in order to make that subjective interpretation a little bit more objectively measured, what some of the courts have done is that they looked at the IQ test for guidance. And if you have an IQ of more than 70, then a court may believe that that child is not substantially handicapped mentally to make decisions. If it's less than 70, I can, for instance, say 45, then that is considered a substantial handicap, and you will be found to need um, some kind of assistance, provided that that IQ is not expected to increase significantly in the future. There are different types of guardian advocacy. You got the guardian advocate of the person, and you got the guardian advocate of the property. When we're talking about guardian advocate of the person, we're looking to make personal decisions that include determining where a person lives, consenting to medical or mental health treatment, and making social decisions like um, where are you gonna go for leisure activities, who are you going to associate yourself with, if you want to go to church, for instance, um, and those kinds of personal decisions. When we're talking about guardian advocate of the property, we're basically um, asking the court for permission to do some major contracting, suing, defending lawsuits, managing property, or making gifts. Uh, Now, that is excluding decisions regarding Social Security benefits. Because remember, you can be designated as a representative payee by the Social Security Administration, and since that's a federal statute and a federal agency, the state government of Florida and its judicial system does not have any kind of inherent powers to preclude you from exercising your federally appointed duties. Okay? So it's a difference between your federal duty of being a representative payee and your state duty of managing your ward's property. Now, uh, whether you're appointed a guardian advocate of the person or a guardian advocate of the property, you can always seek government benefits. That means that if somebody needs food stamps or needs Medicaid or Medicare or needs assistance from the Agency for Persons with Disabilities or any other kind of government benefit, then you don't need a guardian advocate of the property to make those kind of decisions. You, as a guardian advocate of the person, may usually request those government benefits. Now, here's an important question. are the powers of the guardian advocate the same as the powers of a full guardian? Now, the question is yes, but it really depends. This is when we get into um, the complexities of our judicial system. Now, under Chapter 744 of the Florida Statutes, a guardian advocate has the same powers and duties as any other type of guardian. The only limit is whatever a court's order sets out as the types of decisions delegated. Now, what does that mean? Well, that basically means that whatever that order says that you can do as a guardian advocate, then that is the scope of your authority to make decisions on behalf of your ward. If the document says that you were delegated the right to decide whether the ward gets married or not, then great. That's what the court order said. Mind you, this varies from jurisdiction to jurisdiction. I have sought guardian advocacy for many clients in several jurisdictions, and I can tell you that every jurisdiction is different. Some jurisdictions will be more liberal than others. Just to give you an example, in Orange County, Florida, because of what has happened historically, the judges tend to be more conservative in which rights they're about to delegate to a guardian advocate. And when you're looking at the story, you just need to look at the investigative report that we highlighted at the beginning of this presentation. Some guardians abuse their powers and replace their own belief system on their wards to the extent that it can cost their lives. In that sense, the Florida legislature has acted, and now you do need to include in your petition whether there's a DNR or not and how it was procured. But that has sent out a chilling effect in the judiciary, so they don't want the legislature to keep filling these loopholes. They want to make sure that this kind of situation doesn't happen in the future, and that's why you will see judges more reluctant to delegate personal rights and property rights too, but more focused on the personal. Just to give you an example, I had a case in which a child was turning 18. That child was accepted to college. The child had a developmental disability diagnosed before the age of 18. The parent believed that the child needed assistance in making decisions. The case was brought to court. Remember, and this is something that we will discuss, the children have the right to their own attorney. And the attorney for the child disputed the parents' request for a guardian advocacy to be decided or implemented due to the fact that this child had an IQ of more than 70. That now there was definitely um, a disagreement between what the parent thought um, the child was capable of doing and what the court thought that the child could do. But definitely, in the end, the court is going to rule for the least restrictive alternative. So if a child is going to college, well, that child has some capacity to make some decisions. Um, Definitely, a if that child wanted some assistance in making some financial decisions or some personal decisions, that child could just draw up a power of attorney. They didn't need a guardian advocate. Um, and in the end, that's what the court ruled. So just because you believe that your child needs a guardian advocate, or you believe that there's some authority that needs to be delegated to you as a parent, um, that doesn't mean that the court will award it. Okay, um, it's very important for us as parents to understand that the court will always look to the least restrictive alternative. Now, lastly, we're going to talk about how to obtain a guardian advocacy. The first question is, do you need a lawyer? Well, you really don't need a lawyer under Florida law. Um, you can always find the forms online, and if you do need some legal assistance, you can call us for free legal advice. Now, how do you represent yourself? Now, if weren't able to obtain a private lawyer, or you didn't qualify for free legal assistance through one of our organizations in the legal services system, you are going to have to do it yourself. And it's a simple process. It's basically 5 steps that you need to take. The first one being finding the forms online, second being filing the forms in court, the third, requesting a background check, fourth, arranging a meeting between the proposed ward, meaning your loved one, and your loved one's counsel. Okay, because remember, your son or daughter will be represented by an attorney in court. Uh, that attorney is going to look out for the best interest of that child. They want to make sure that you or the proposed guardian advocate is the right person for the job. And lastly, step 5, you're going to appear in a hearing in court where the judge will make the final decision as to your petition. Looking at step 1, finding the forms offline. Well, your first step is to look at which circuit court you need to file your petition according to the place where you reside. So if you have lived for more than 6 months in a specific county, then you're just going to look at that county in this map and find out which circuit court is right for you. So for instance, I live in Orange County. If we look at the Central Florida area, then you'll see that the Orange County belongs to the 9th Circuit. So if I'm going to file a petition for guardian advocacy on behalf of my son, I'm going to file it in Orange County, the 9th Circuit Court. Then, once I select the circuit court, I'm going to go to that court's website, and I'm going to look for their forms packet. I'm going to download that packet, and then I'm going to fill it out. And it's a bunch of forms. Um, but each um, each circuit has its own forms. So if you live in Hillsborough County, you can't use the forms from Orange County to file your petition for guardian advocacy. It might go against your common sense, but because the law is open to interpretation, the judges in each circuit have developed their own ways of doing things. So, a guardian advocacy in Hillsborough County is a guardian advocacy in Hillsborough County. It's not going to be the same as in Miami-Dade or as in Osceola or Seminole. The second step is for you to file forms in court. Now, the best thing for you to do is to make 3 copies of your forms. You go to the courthouse, ask for instructions on how to get to the clerk of court's office. Once you get there, you're going to pay a filing fee. If you are indigent, you can request for the clerk to waive the filing fee by filing an application for determination of indigent status. If you qualify, then you won't need to pay the court. Then, once the filing fee is either paid or waived, you're going to give a copy of the original petition with all the supporting documents to the clerk. You're also going to give a second copy to the clerk because your potential ward, your loved one, the person with a developmental disability, is going to need to have a copy of those documents. They need to be notified that there's something going on that will affect their rights. So the clerk is going to mail those documents to the ward. Now, depending on the county, some counties will ask you to mail that notice yourself. So remember, each county is different. General rule, it's the clerk that's going to send out the notice. As an exception, you may have to send that notice yourself, and you need to send it by mail. You can't just go to your house and just hand it out to your loved one. Okay, it needs to be sent out by mail to the potential ward's last known address. And then the third copy, you are gonna have the clerk punch it, so you have some evidence that you did file those documents on that day, and you keep that third punched copy for yourself. The third step, you request a background check. Now, some background checks are performed through live scan. It's just a document that you file with one of the live scan providers, asking for a screening. And what they do is that they send out a copy of your fingerprints with some personal information to the Florida Department of Law Enforcement and the Federal Bureau of Investigation, and they look to see whether you have any criminal records. And now those results will come directly from the government to the clerk. So you can't get a certificate and file it with the court. No, it's the government that's going to send out the document directly to the clerk. There are some circuits that also require some kind of certificate from um, the Department of Children and Families, or DCF. So it all depends on your county. Uh, but there will be some criminal investigation to make sure that the proposed guardian advocate um, doesn't have any uh, uh, criminal records that could interfere with that person's um, ability or qualifications to work as a guardian advocate. Step 4, again, you're going to need to arrange a meeting between your loved one and your loved one's attorney. That attorney may be a private attorney that's appointed by the court. If that ward has any kind of property, then that property will be used to pay that private attorney. If um, if your loved one doesn't have any money, then the government will pay that private attorney, or will refer your case to another government agency that will provide representation for your loved one. But you need to allow that to happen. Sometimes you go to that private or government attorney's office, or sometimes that private or government attorney will go to your house. Um, it all depends on the county and how they like things to be done. And that attorney is going to ask questions. They're going to determine whether guardian advocacy is the least restrictive way of making sure that your loved one makes decisions. And, um, you know, it all depends on the attorney. There are some attorneys that are more strict than others, and you will need to submit more documentation in some circuits with some stricter attorneys than in others. Uh, you, just to give you an example, one of the things that you will need to do in court is to submit an opinion, a medical opinion from a doctor saying that your child cannot make certain decisions. If if you use the forms provided by that circuit, um, and you present those forms, that form that's provided by the court, to the attorney, saying, "Well, the doctor just filled out this form and just signed um, the form on the bottom." That other attorney, if it's one of those strict attorneys, may say, "Well, I don't trust the court form. I want this medical opinion to be in that doctor's letterhead, because I don't trust that this is a legitimate form signed by a doctor." Well, that's your ward's attorney, and that's what that ward attorney wants. And if that's what's going to get that guardian advocacy approved, then you may have to go that extra step and get your doctor to make that medical opinion about that ward's capacity in a letterhead. So it all depends on the county. It all depends on who's the attorney for the other side, but you want to make sure that this happens. Now, finally, the fifth step is the hearing in court. That's where the judge is going to look at all the evidence and determine um, whether there are any other less restrictive options available. Now, what are the responsibilities as a guardian? Well, as a guardian advocate, you are taking a fiduciary duty and you must answer to the oversight of the court. So once you have the order appointing you as a guardian advocate, the process doesn't end there. Okay, that document is going to be referred to a court officer that's going to look at your petition, okay, and is going to ask for more documentation. They're going to look at a plan of care, okay. Now, that initial plan is due within 60 days of your appointment. Not only that, but you will also need to take a court approved guardianship education course 4 months after your appointment. Now, occasionally the court may waive this requirement, but it's not likely. And in addition to that, if you're a guardian of the property, you will have additional duties to report. Now, if you have any questions, please feel free to contact Florida Rural Legal Services at the number of your screen.
We have come to the end of our presentation. However, if you need help, remember, you're not alone. You can always contact your nearest legal services provider for assistance in this matter. Legal services are provided for free to those who qualify.